Hello everyone. Today in this video, we study about subject financial laws, and the topic we're going to cover today is securitization and reconstruction of financial assets and enforcement of Interest Act 2002. So today we'll be studying about historical background, its object, its scope, its applicability, non-applicability, and of course the general overview of the law. Right. So let's proceed. Now I'll be sharing my screen with you all. Right. So let's move. So SARFAESI, as I told you the full form, it is the securitization and reconstruction of financial assets and enforcement of Interest Act 2000. Right. So it's a very important step towards banking reforms, as you can see. So today in this video, it will help you to understand and help you to know the history behind the enactment of this particular act, and to understand the mechanism of how the act operates in banking sector. And of course, we'll also identify the loopholes present in the act, and also provide possible solutions to the loopholes. We'll find out what are the loopholes and try to find out the solution to it, right? So let me tell you first the historical background of this act. So under the guidelines of central and state government, banks and financial institutions granted loans liberally to the small and large industries, companies, etc. Right? So what happened as a consequence? It resulted into increasing amount of dues, and banks and FIs faced difficulty in recovering of loans. That is the bad debts, NPAs. So public money got stuck and lead to a rise of non-performing assets. That is NPAs. The Sikh Industrial Companies Act 1985 aggravated further the problems of NPAs. So the central government, in order to meet the crisis, formed a committee under the chairmanship of Mr. Nasim. So on 30th September 1990, more than 15 lakh cases were filed by public sector banks, and 304 cases by FIs found pending in various courts for recovery of loans. So a whooping sum of 6013 crores was found due, and the committee suggested for the establishment of debt recovery tribunals. So hence the Recovery of Debt Due to Banks and Financial Institutions Act 1993 came up. Okay, so this is how it began. So the Reserve Bank of India took various possible decisions to control the problems of rising NPAs. Like for example, one-time settlement (OTS) scheme was introduced in 1997. Then corporate debt restructuring. We'll be studying this in our next unit. CDR scheme in 2001. But still, the problem of rising NPAs could not be curbed down, as there was a lack of securitization law in Indian legal framework, right? So, okay. So the amount of debt was 12,000 crores. Hence, the central government once again appointed another committee under the chairmanship of Mr. Anthayuradina to examine banking sector reforms in the legal system. Now, the committee suggested that there is a need of an act which would deal with securitization, and hence this act came into existence in 2002. That is securitization and reconstruction of financial assets and enforcement of Interest Act 2000. Right? This is how the act came into existence. Now, let's understand about the object and scope of the act. Now, registration and regulation of securitization companies and reconstruction companies by Reserve Bank of India was the object. Securitization and reconstruction of financial assets was the another object. And enforcement of security interest was another object and scope. Now the said act enables and empowers the secured creditors to take possession of their securities. and to deal with them without the intervention of the court or tribunals, and also alternatively to authorize any securitization or reconstruction company to acquire financial assets of any bank or financial institution. Now, the Act has been empowered with the overriding effect over the other legislation, and it shall be in addition to and not in derogation of certain legislation. And this Act extended to whole of India. That was the scope. It was extended to whole of India, right? Now, what was the applicability of the Act? Where was this Act applicable? Now, the debt must have been, first applicability condition was the debt must have been classified by banks and FIs as NPA. It was the first applicability condition. The next was the provisions of this Act are applicable only in case, right, where the amount become due and it is above rupees 1 lakh. Okay. Now, NPA loan accounts where the amount is less than 20% of the principal amount and interest are not eligible to be dealt with under this Act, of course. So loans granted by banks and FIs should be backed by securities charged to the bank and FIs by way of hypothecation or mortgage or assignment or any charge. So this was the applicability of the Act. Here it was applicable. Now, there are certain cases where the Act is not applicable. Like, for example, any lien on any goods, money or security given by or under the Indian Contract Act 1872, like, or the Sale of Goods Act 1930, or any other law for the time being in force, right? The next non-applicability was a pledge of movables within under section 172 of the Contract Act 1872, and the creation of any security in any aircraft as defined in section 21 of the Aircraft Act 1934, and creation of security interest in any vessel as defined in section 355 of the Merchant Shipping Act 1958, and any conditional sale like hire purchase or lease or any other contract in which no security interest has been created. Over here, the Act was not applicable. Another things where it was not applicable, where it is not applicable, is any rights of unpaid seller under section 47 of the Sales of Goods Act 1930. And any properties not liable to attachment or sale under section 61 of the Code of Civil Procedure 1908. So any security interest for securing repayment of any financial assets not exceeding 1 lakh rupees. I'm talking about non-applicable criteria right now. And any security interest created in agricultural land. And last, any case in which the amount due is less than 20% of the principal amount and interest thereon. So I've just told you about the applicability and non-applicability of the Act, right? Now let's understand the general overview of this particular Act. Okay, one by one. Now, this Act is divided into 6 chapters, as you can see, containing 42 sections. I'll tell you how the chapter deals with, each chapter deals with. Chapter 1 deals with preliminary, that is title, extent, definitions. Chapter 2 deals with regulation of securitization and reconstruction of financial assets of banks and FIs. Chapter 3 deals with enforcement of security interest. Chapter 4 deals with central registry. And chapter 5 deals with offenses and penalties. And last, chapter 6 deals with miscellaneous provisions, right? So in this particular video, I've just made you understand what is SARFAESI Act 2002 and why it was important to take this, to bring this act into like enactment and implementation, right? As I told you, the act was enacted by the parliament, right? To control the NPAs, and we have also understood the objects and scope of this particular act, along with its applicability and non-applicability. It is where it is applicable and where this law is not applicable, right? And of course, the general overview of the chapters of this particular act, right? So in the next video, we'll be covering more things, right? Like we'll be finding out, we'll be understanding about the loopholes and procedures and a lot of things about the same act. So like see you all in the next video. And then I want you all to go through the PPT and also prepare notes because what I can teach you in the presentation is just an overview, right? You'll have to prepare your own notes. You'll have to refer books, right? Because when it goes to law, you'll have to be very elaborate, right? So you should be able to write down in elaboration. So I hope you all understand. So see you all in the next video. Till then, take care.